Thank you for coming back for day two, and we're grateful that, or we're glad rather, that you've all navigated your way here to the historic Ames courtroom in Austin Hall. With that, I'm going to go ahead and introduce our panelists for the first panel of the morning. This morning's panel is going to focus on federalism as a instrument of the separation of powers. Our moderator for this morning's panel is Judge Stephanos Bibas, who sits on the United States Court of Appeals for the Third Circuit. Judge Bibas is a graduate of Columbia University, of the University of Oxford, and of Yale Law School. He clerked on the Fifth Circuit for Judge Higginbotham, as then clerked on the United States Supreme Court for Justice Anthony Kennedy, where one of his co-clerks was Judge Kethledge, last night's speaker. Judge Bibas's career took him to the U.S. Attorney's Office in the Southern District of New York before he entered academia, where he was is a scholar of criminal law and criminal procedure. He taught at the University of Iowa, as well as the University of Chicago, and then most recently at the University of Pennsylvania, where he directed the Supreme Court Clinic and argued several times before the United States Supreme Court. Also on the panel today, we have Professor Ernest Young, the Alston and Byrd Distinguished Professor at Duke University Law School, where he has taught since 2008, just in time to get there for Justice Campbell to be one of his students. Professor Young is a graduate of Dartmouth College of Harvard Law School. He clerked on the First Circuit for Judge Michael Boudin, and then on the United States Supreme Court for Justice David Souter. He was in private practice at Covington and Burling, and he previously taught at the University of Texas. He's a scholar of federal courts, federalism, and foreign relations law. Up next, we have Justice Sarah Campbell, an associate justice at the Tennessee Supreme Court. Justice Campbell has served on that court since 2022, a lifelong Tennessean. She's a graduate of the University of Tennessee, as well as Duke University Law School. And while at Duke, she also earned a master's degree in public policy. She clerked on the 11th Circuit for Judge William Pryor, and then on the United States Supreme Court for Justice Samuel Alito, and was in private practice at Williams and Connolly, and served in the Tennessee Solicitor General's office before she took up her current seat on the bench. Up next, we have Professor Molly Brady, the Louis Brandeis Professor and Deputy Dean of Harvard Law School. Professor Brady is a scholar of property law and of local government and land use law. She's a graduate of Harvard College and Yale Law School. She clerked on the First Circuit for Judge Bruce Selya and previously taught at the University of Virginia. And last but not least, we have Professor Jim Tierney, who's a lecturer on law here at Harvard Law School. Professor Tierney is a graduate of the University of Maine and the University of Maine Law School, the latter of which he attended while serving in the Maine state legislature. From 1981 to 1991, he served as the 51st Attorney General of Maine, and since then he has devoted his life's work to helping the public, and perhaps more importantly, attorneys generals themselves understand the role of the state attorney general, where he is in that capacity taught at Columbia Law School and here at Harvard. They're going to each speak for a few moments, and then there will be some moderated discussion, and then at some point there will be an opportunity for audience questions. Folks will be running around with microphones at that time, so just raise your hand if you have a question, and please wait for the microphone to reach you before asking your question so that those who are watching online can also hear your question. With that, I'm going to turn things over to Judge Bibas. Thanks so much for being here.
Thank you, Ben. Thank you, FedSoc. Thank you, distinguished co-panelists. So our topic, we normally think about separation of powers maybe at the federal level, but what's the role that states have in it? And not just states. There are multiple layers of government. Often we don't pay attention to counties, to cities, to towns. But the breaking down of power may work as a check, but how well do these checks work? And do they frustrate coordination, effective policy, et cetera? We're blessed to have a very distinguished panel here, and I think we have a range of perspectives here. So without any further ado, let me turn it over to Professor Young to kick things off.
Thank you. I want to start by thanking the Federalist Society, especially Benjamin, for organizing this conference and inviting me to participate. Always important to the top of my search part.
Talk about federalism. I was coming out of law school and clerking in the mid-1990s when the Rehnquist Court was beginning its Federalist revival. It decided cases like New York versus United States versus Lopez, Seminole Tribe versus Florida, that renewed the Supreme Court's effort to enforce constitutional limits on national power. Those cases mixed history and political theory and functional dynamics of federalism, and I thought they were just fascinating. That's what inspired me to become a legal academic. Nowadays, I think the Roberts Court is more interested in separation of powers than federalism. Most of the structural constitutional action is under the Appointments Clause or the removal power or at the intersection of administrative law and constitutional law. But part of the point of this panel is to say that horizontal separation of powers and federalism are part of the same broad system of checks and balances that our founders instituted to prevent the concentration of power and to protect individual liberty. Madison, as usual, put it best in Federalist 51. In the compound Republic of America, the power surrendered by the people is first divided between two distinct governments, and then the portion allotted to each is further subdivided among distinct and separate departments. The Constitution's federal structure affords a double security to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. But the other point that I want to add, which Madison surely knew as well, is that states aren't just another department in this separation of powers. They are themselves complete governments with a measure of sovereignty, their own constitutions, and their own wells of democratic legitimacy and support. So I hope to make two key points about states and the separation of powers. First, separation of powers is the key to preserving state autonomy. The founders believed, and I think it's an article of faith in this society, that the national government is one of limited and enumerated powers. The 10th Amendment makes this clear, but some of these powers are broad, and they're mapped onto things like commerce among the several states that were bound to expand over time as the economy grew and became more integrated. And they threw in a necessary and proper clause that it's hard to limit very sharply without doing violence to its textual meaning. So I'm here to tell you that enumerating powers hasn't been very successful as a means of limiting national power. The capaciousness of the text and the court's wish to stay in their own lane, especially after the 1937 Judicial Revolution, has made them really unwilling to enforce limits on national power if they can't find bright lines to do so. And I think, for instance, the main reason that Charles Freed nominated me for the Bator Award back in 2005 was for an amicus brief we worked together on in Gonzalez versus Raich, the medical marijuana case. That was the first time the Rehnquist Court's Federalist revival encountered a big, important federal statute, the Controlled Substances Act, rather than just a symbolic little provision like the Gun-Free School Zones Act. And the sad fact is that our side lost that case, with Justice Kennedy and Scalia voting to uphold Congress's ability to regulate marijuana consumption even when no money changes hands and nobody crosses the state line. But Justice Scalia, like many conservative jurists, cared about bright line rules, and he couldn't find one to limit Congress's enumerated powers in a meaningful way. So I don't think that's likely to change. But just because Congress has the power to regulate almost anything doesn't mean it will get its act together to do so. Have you been watching these people? And that's where the separation of powers comes in. The legislative process has two features that really protect states. One is that the states are represented, at least to some extent, in Congress. But more importantly, it's just hard to get legislation through. The Schoolhouse Rock, I'm just a bill cartoon remains one of the most important treatments of separation of powers in our culture. You youngins can still find it on YouTube if you haven't seen it. Did you ever wonder why Congress has any business requiring school buses to stop at railroad crossings, which is the bill that's in play in the video? You might think that's a federalism problem, but the Schoolhouse Rock writers weren't wrong to think that the chief constraints on Congress regulating even something like that would come from the difficulty of navigating Article I's separation of powers in the legislative process. So the big threat to federalism today is that the national government doesn't use the legislative process anymore to make law. It uses executive orders and administrative regulations and adjudications. It does this because it's so much easier to make federal law that way. And so the separation of powers limitations on actions by administrative agencies and presidential fiat, things like the major questions doctrine, for example, take center stage as protections for federalism. But much of the separation of powers debate isn't so much about new federal measures being enacted as how existing ones will be interpreted and enforced. And that separation of powers debate is both horizontal and vertical, because the states play a direct role in these processes, which leads to my second point. And that is that states play a critical role in the national separation of powers because they are intimately involved in interpreting, enforcing, challenging, and competing with federal law. Most federal regulatory and benefit schemes are enforced by the states through what we generally call cooperative federalism, for a number of reasons, including limited federal resources, Congress's political preference for state involvement, and the need to tailor federal law to the different circumstances in different jurisdictions. State governments end up being the key actors who implement federal law. The classic examples are the Clean Air Act and the Clean Water Act, under which the national EPA identifies pollutants, sets standards, but then the states are responsible for coming up with implementation plans, interpreting those statutes, and figuring out what to do. So cooperative federalism is a means to leverage federal power more broadly, but it also often turns into what my co-clerk Heather Gerken calls uncooperative federalism. That is, states often push back on the priorities of federal regulators, they interpret federal laws differently, or sometimes they flat out go on strike. They often get their way that way. And they're able to do this because, first of all, the anti-commandeering doctrine prevents national authorities from just requiring them to do exactly what the federal authorities wish. And second, the states remain sovereign in the fundamental but sometimes overlooked sense that they get to choose who their officials are and what their priorities will be. All of this is facilitated by the fact that the states are complete governments with their own regulatory apparatus, and they're empowered to stand up to the feds by their own well of democratic support and legitimacy. These characteristics also fuel the states' emerging role as the primary challengers of federal measures in court. In recent years, the states have challenged Obamacare, the Obama administration's immigration measures, the Trump travel ban, the Trump religious exemption to the Affordable Care Act contraceptive mandate, the Biden student loan giveaway, and any number of other measures. My friend Daniel Francis calls this the litigation safeguards of federalism. A lot of people, including many conservatives, are nervous about all these state lawsuits. But most of these cases, someone is going to sue. And states are better litigants not only because they have more resources and expertise, but also because they're politically accountable for their actions in litigation and bringing these cases in ways that other big public interest organizations like the Sierra Club or the Chamber of Commerce simply are not. But the most important ways that states challenge national policy is by presenting an alternative to it. Because they are complete governments in their own right, they can not only disagree with federal policy, but formulate and implement distinct policies of their own. They can, as my friend Heather says, dissent by deciding. California can try to lead the way on climate change. Texas can illustrate the advantages of an economic model that provides economic opportunity for everyone and doesn't try to regulate private industry out of existence. And these kinds of examples become critical to the national political conversation because they're not just speculation and theorizing, but actual instances of how real alternative policies have worked out on the ground. You're going to hear a lot in the next few months about threats to our democracy. But I think the most likely way our democracy would die would be to wither away because the same group is locked in and always controlling national policymaking. That's more likely to happen if the political opposition has no opportunity to demonstrate the viability of policy alternatives. And that's hard to do if the opposition never has the opportunity to govern anything. States create that opportunity. Think how many state governors have successfully challenged a president when their party is out of power in Washington, based on examples of how their policies already worked in their home state. We've gotten away from governors in presidential politics recent years. I think that's been a mistake. In any event, the bottom line is that we need to stop thinking about states as doing their own thing wholly apart from the national government and think about the role that the states play in our national political process and the national separation of powers. Thanks.
Justice Campbell.
Thank you. First, I want to begin by thanking the Federalist Society for the invitation to be here today, and I'll join Professor Young in thanking the Benjamins. I don't think there's ever been this high a concentration of Benjamins in one place, but we are grateful for your leadership on this conference. It's really wonderful to be here with my distinguished co-panelists, and especially with Professor Young, from whom I learned everything I know about federal courts and federalism, and he is a big part of the reason I made the move back to Tennessee after practicing in DC for a few years, so I owe him a special thanks for that. So discussions about the separation of powers often center on the political branches, but federalism often also has important implications for the judicial branches. My remarks today will focus on judicial federalism. First, I'll discuss federal and state courts' overlapping authority to decide issues of federal and state law. And I'll identify some of the ways in which this overlapping authority creates friction between the federal and state courts and can injure state sovereignty. Second, I'll point out some of the key differences between state and federal courts and among state courts and explore whether those differences should change the nature of the judicial role in any material way. So first, overlapping authority between federal and state courts. Let's start with some context and background. You may not know, because law schools overwhelmingly focus on federal law, but over 95% of cases filed in the United States each year are filed in state court. State courts are courts of general jurisdiction. They hear over 100 million cases each year compared to several 100,000 that are heard in federal courts. And in our system of dual sovereignty, state courts have authority to decide issues of federal law and state law. They're presumed competent to decide issues of federal law unless Congress divests them of that jurisdiction. The notion that state courts have authority to adjudicate federal law issues was never really disputed. Hamilton made clear in Federalist number 82 that Article 3 was not intended to divest state courts of their pre-existing authority to adjudicate issues of federal law. Whether federal courts would have authority to hear issues of state law, on the other hand, was a question that generated significant debate at the founding. The Anti-Federalists feared that the Constitution's grant of diversity jurisdiction to federal courts would make federal courts too powerful and eviscerate state judiciaries. One result of the Madisonian Compromise was that the grant of diversity jurisdiction remained in the Constitution, but it left it up to Congress whether to establish lower federal courts. The Judiciary Act did give lower federal courts jurisdiction over diversity cases, but it imposed a monetary threshold. That monetary threshold has been ratcheted up a bit over the years, but the last increase was nearly 30 years ago. The current threshold is $75,000. So some cases that are brought in federal court under federal question jurisdiction also present state law issues. Federal courts can hear those issues too under their supplemental jurisdiction. So we have this system of overlapping authority. State courts sometimes decide issues of federal law incorrectly, and federal courts, believe it or not, occasionally make mistakes on issues of state law. So what recourse is available when that occurs? I think it's interesting to see the contrast between those two situations. So when a state court decides an issue of federal law incorrectly, the United States Supreme Court has authority to review that decision subject to some limitations like the adequate and independent state ground doctrine. Congress granted the United States Supreme Court that authority in the Judiciary Act of 1789, and it was upheld in Martin versus Hunter's lessee. The availability of Supreme Court review ensures that there is uniformity and federal supremacy in federal law. But what happens when a federal court decides an issue of state law incorrectly? The state's highest court in Tennessee, that's the Tennessee Supreme Court, is the final authority on the interpretation of a state law. But when a federal court decides an issue of state law incorrectly, there's no way for the state's highest court to directly review that question. The losing party in federal court is not allowed to appeal to the state court, for example. And because we have claim preclusion and issue preclusion doctrines, the losing party also can't just start over in state court and try to get a different ruling from the state court on that question. So what that means is that state courts often have no mechanism to correct a federal court's incorrect, eerie guess on an issue of state law, other than to wait for that issue to arise on its own in state court in a similar case. And that, of course, can sometimes take years if it happens at all. So during that interim time period, the state is deprived of its sovereign authority to enforce its laws. Certification is one way to avoid this problem. Nearly all states have adopted certification procedures that allow federal courts to certify questions of state law. There's a rule in Tennessee Supreme Court Rule 23, says we may answer certified questions of law from the federal courts. The certifying court must determine two things: that the question will be determinative of the cause of action in that case, and second, that there's no controlling precedent on the issue. Federal courts are not required to certify, however. Most federal circuits give their federal district courts and federal circuit courts largely just discretion to decide whether an issue should be certified. And frequently, federal courts choose not to certify for a variety of reasons: the delay that can ensue, the sense that they are just as competent to decide the issue of state law as the federal court. I'm sure there are other reasons that perhaps our moderator can enlighten us on in the course of this conversation. Let me just give you an example of the friction that can occur when a federal court chooses not to certify a question. So this is a case that arose in the Sixth Circuit several years ago. It's called Lindenberg versus Jackson National Life Insurance Company. So several years ago, Tennessee's legislature passed a law creating a statutory cap on punitive damages and non-compensatory damages. The cap that was at issue in this case was the punitive damages cap. It capped damages at either the double the amount of total compensatory damages or $500,000, whichever is greater. There was a breach of contract action that was originally filed in Tennessee state court. It was removed to federal court. A jury awarded the plaintiffs punitive damages that exceeded the statutory cap. The defendant predictably argued that, the plaintiff predictably argued that the cap violates Tennessee's constitutional right to trial by jury and the separation of powers. The district court initially certified those questions to the Tennessee Supreme Court. The Tennessee Supreme Court declined to certify because at that time, it was not clear that the constitutionality of the damages cap would be determinative. There was a preliminary question about whether punitive damages were even available as a matter of law in Tennessee, and that question had not yet been decided, and that question also was not certified along with the constitutional questions. So the court declined to certify, made clear in the certification order that declining to certify at that point didn't indicate an unwillingness to certify at a later point in the proceedings when it was clear that the issue would be determinative. So there was an appeal, and there was an appeal, went up to the Sixth Circuit, and the state urged the Sixth Circuit to certify the questions. No party objected to certification. Everyone was willing for the Sixth Circuit to certify the constitutional question of whether Tennessee's damages cap violates the state constitution's right to trial by jury or separation of powers. But the Sixth Circuit declined to certify and instead held that Tennessee's damages cap violates Tennessee's constitutional right to trial by jury. So take that in for a second. A federal court held that a Tennessee law violates the Tennessee Constitution without giving the Tennessee Supreme Court an opportunity to weigh in on that question. So it wasn't until several years later that a similar issue, the constitutionality of Tennessee's cap on non-compensatory damages, came up within the state court system, and the Tennessee Supreme Court had an opportunity to weigh in. I was not on the court at that time, but in a case called McClay versus Airport Management Services, the Tennessee Supreme Court reached the opposite conclusion of the Sixth Circuit and said it does not violate Tennessee's constitutional right to trial by jury. So in the interim time period, Tennessee was unable to enforce its state law. Let me briefly, my time is running short, but let me briefly just touch on, so that was maybe one of the downsides of judicial federalism, but let me talk for just a moment about the benefits of judicial federalism. One of those benefits is that judicial federalism allows for state-level experimentation and variation. Chief Judge Sutton has written on this topic. You may have seen his books, 51 Imperfect Solutions and Who Decides, about the differences among state constitutions and protection of constitutional rights and structural differences between state and federal courts and among state courts. I think these are really, really important topics for us to explore. And during the Q&A, I hope to explore whether some of the structural differences in particular should make us think differently about the role of a state court judge. And three of those differences I'll just point out to get us started are that state court judges have common law decision-making authority. There's not much of that left in federal courts, but there's quite a bit of common law left in state courts. State courts are elected in many cases, or at least are subject to some sort of electoral accountability, such as retention elections. And third, in states, it is often the case that state constitutions can be much more easily amended than the federal constitution. State laws, statutory law, is also more easily amended. There tends to be less gridlock in state legislatures than in Congress. So hopefully we can talk more about what those differences mean for the judicial role. Thank you.
Professor Brady.
Great. Let me join the chorus of thanks to the Federalist Society, also to Ben Ponce and Ben Rolsma. I recognize them as individuals since both are my students. And let me also say on behalf of HLS and my administrative capacity, thanks to all of you for being here. We're really excited that our chapter is hosting this. So following on my excellent co-panelists, I just want to talk about federalism in subject matter limited form. So I call federalism my side hustle. My main love in life is property. And so today I'm going to talk about some lessons for federalism from constitutional property law. A variety of interesting federalism puzzles arise when state common law crashes into the federal constitution. So my remarks are going to focus on the takings clause, but these problems recur outside of that context, basically anywhere where the scope of federal protection is linked to the positive law of a state. So some of you may be familiar. There are some pushes toward this, I think, in Fourth Amendment law right now, toward a more positive law model, and I think this is the experience of the takings clause is illustrative of some of the puzzles that come up. I'm going to basically use my very short time to ask two questions. The first is what we can learn about federalism from the role of state-specific law underlying or shaping federal constitutional protections, and a little bit about how the winds may be changing on that front. And second, what can we learn about federalism from the largely absent potential of states to innovate through state constitutional interpretation in the context of the takings clause and the state takings clauses? So I'm going to ask both of those things, and then hopefully during Q&A I'll have a chance to offer some thoughts on what I think forces both of these trends. So first, what can we learn about federalism from the role of state-specific law in underlying or shaping federal constitutional protection? Let me take a step back and explain kind of what I mean by this. So the takings clause in the Constitution, which I hope you've all learned about, protects property, of course, from being taken for public use without just compensation. And traditionally, in deciding what counts as property, that has meant what the states define as property. The iconic quote that courts tend to go to here is from Board of Regents versus Roth from 1972. So I'll quote here, "Property interests are not created by the Constitution, rather they are created and their dimensions are defined by existing rules or understandings that stem from an independent source, such as state law." Traditionally, one of the reasons for the sort of positivist deferral exemplified by this Roth quote was the idea that property is the most local of state law topics. Land cannot be moved, at least yet, and it's intimately constructive of local culture, everything from sort of geography, very much a sense of place. Letting states experiment both with forms of property, so types of property interests, and also with regulations on that property, could advance local objectives and conditions and some of these federalism goals. So I'll give you a good example, which is the different rules of beach access in New Hampshire versus Oregon. Yes, there are beaches in New Hampshire, fun New England fact. So Oregon has really permissive common law rules that permit customary access to beaches. You may have read a case called Thornton versus Hay in First Year Property that talks about this. New Hampshire rejects customary rights entirely. What counts as a taking in New Hampshire might be different or might not be a taking in Oregon, given this underlying customary law within the state. A few years ago, I started noticing signs that this Federalist dimension of takings law was starting to change, in my view. And it started with a case called Murr versus Wisconsin, which is from 2017. Murr is not terribly well known, but it's the last sort of liberal victory in a takings case. It's a Kennedy 5-4 decision authored by Kennedy. And it's a weird little niche case about what we call in takings law the denominator problem. So essentially, how do we decide what unit of property is the right unit for the purposes of running various takings tests to assess whether a taking has occurred? The Murr majority, in answering this question, looked beyond Wisconsin law, which arguably recognized the plaintiffs as having kind of two distinct parcels. So there should have been analysis of a smaller unit of property rather than the larger one that the Supreme Court endorsed. And the reason that they looked, or one of the ways in which they looked beyond Wisconsin law, was basically to say, hey, there's a long history of regulations treating these kinds of properties that are on water as one, or merging them under certain conditions. And they pointed to a 100-year-old regulation from New York that was supposed to be shaping the expectations of a landowner in Wisconsin. And so this sort of resort to a jurisdictionless law in takings cases stood out to me. More recently, a more famous decision, probably Cedar Point Nursery versus Hasid in 2021. This is a takings case that said that a California labor access law was a per se taking. The opinion relies quite heavily on a sort of jurisdictionless right to exclude, which is no doubt important in property, and which was violated by the law authorizing organizer access. But state-specific law posed a trickier puzzle, and my view is we might have gotten more insight on how exactly property federalism works had we had more on what exactly was wrong with state-specific law. So in Cedar Point, the California labor access law had been in effect nearly 50 years. This is interesting to me because the opinion in Cedar Point signals that civil rights laws are not a problem, but those are also about 50, 60 years old. But it didn't explain why civil rights laws enabling access were permissible, but the labor access law was not. I think there are lots of answers to this question. One might be, one is federal and the other is sort of state, and so federal beats state. It could be that civil rights with their grounding in constitutional protection are just different than labor rights, which others have argued about whether those are protected. But the minimization of state-specific law, of California law in the Cedar Point opinion meant we didn't get what might have been helpful answers to those questions. And so I think these puzzles will keep recurring. I view the trajectory as completed a bit. This past term in Tyler versus Hennepin County, a case that definitely reached the right result. Headlines after the case made me laugh. One was Supreme Court makes everyone happy for once. The facts there were truly awful. There was a widow who owned a condo. She fell into some tax debt. And a Minnesota statute enabled the state to keep the surplus beyond what she owed as after selling it at a tax foreclosure sale. So they sold her property for about $40,000. She only owed $15,000. They kept $25,000. I think that's math. This result didn't make a lot of sense for many reasons, including under Minnesota law, which in all other contexts treated home equity differently than this one. But the Supreme Court started not with Minnesota law, but with history, tradition, and its own precedents. They go to Magna Carta, they go to Blackstone, they go to founding era statutes at the state and federal level, they go to 1880s Supreme Court decisions, and then at the end there's Part D that's about sort of Minnesota law itself. And this to me is the ascent of a kind of general law of property that I think if you espouse the virtues of federalism, you endorse it at your peril. Because today, your favored national law of property may be protected, but I think Murr teaches that it can just as easily be weaponized on the other side to point to long histories of regulation or intrusion on property rights. With a Federalist approach, to again think of Judge Sutton here, you take the bitter with the sweet. So this approach to structure means you win sometimes, you lose sometimes, but it avoids, I think, these sort of broad nationalizing trends. Because my time's really limited, I'm really just going to pose the second bit here as a question with kind of two thoughts. What can we learn about federalism from the largely absent potential of states to innovate through state constitutional interpretation in the context of the Takings Clause? And this dovetails very nicely on Justice Campbell's remarks. Other than the post-Kelo trajectory, which many of you, again, probably have learned about, states generally lockstep when it comes to their takings clauses if the text is identical. So they just follow big federal cases like Penn Central. There's some recent research by a great scholar at Baylor named Jessica Asbridge that's pointing out some potential ways in which this is fracturing. But even where the text differs, so in states, for instance, that have text that prohibits damagings of property for public use in addition to takings of property for public use, we see limited differences in interpretation. So the state courts don't take up the invitation to do something different. Yeah, and I have some tentative thoughts about why this might be, but I think this is really worrisome for a variety of reasons. And it again goes to something Justice Campbell talked about. So not only do federal courts sometimes get state law possibly incorrect, at least insofar as how the state would view it, but it seems like in the context of takings, the long history of it, federal court interpretations of state law or even state constitutions had long-ranging homogenizing influence on state law, such that once the feds did it, the states became sort of worried about varying. And so that's not just a matter of sort of state constitutional interpretation, it's also how I think states treat their common law, that when the federal courts say this is a property interest or this is a valid regulation, few states want to kind of vary from that. So I think it's a worrisome trajectory from the perspective of those who value federalism or think it offers virtues in the variation we get at the state level. I'll conclude there.
Mr. Tierney.
Thanks. Everybody listen up because you're not going to hear anybody like me today, not just now or today, so you might as well pay attention. So the first thing I want to say is, I say this everywhere, make sure you leave a tip for your chambermaid. Okay, she's not working this weekend for fun, cleaning up after you, and you may be a law student and think you're too poor to do it. Believe me, she's poorer than you are. My mother was a chambermaid. So that's my first line to all of you. My second one is for all of you to watch a movie. A movie came out a little over 60 years ago called Judgment at Nuremberg. And it's good to watch it because it's a reminder of the horrors of the Holocaust, but it's about the fictionalized version of the third trial at Nuremberg. Speaking of Justice Jackson last night, of course, he was a Nuremberg prosecutor. And so what happened in that trial and in this movie is fascinating because they were a series of, the defendants were judges. They were judges who loved Germany, loved the law, followed every word of it, followed what the Nazi Party did on the Reichstag. They enforced the law, and then they were on trial. And everybody who is a lawyer or wants to be a lawyer should go back and watch that and debate the very contemporary issues for some of the great actors of our time. All right, as Ben mentioned in the introduction, I was in the legislature when I was a first-year law student, and when I sat down, there was a button on my desk that said yes or no. That was it. All right? It was yes or no. And I represented a hard-scrabble working-class district of people who had problems. And believe me, if you're their local state legislator, they came and told me about their problems. And I lived in that community, and I understood a lot of their problems because that's where I came from. And I understood that problems can be solved in many ways, but I wasn't alone. I had 150 colleagues in the House. I had 33 in the Senate, and we had a governor, and we had different parties, and we worked hard to try to figure out how to solve problems, and that is my challenge to you and your generation here today. You've got some problems to solve. And you can spend your time looking at and wrestling with all of the great issues that my colleagues will discuss later on and later in the day. But at the end of the day, if you're leaving here and you're not solving a problem, what are you doing here? Why'd you bother to come? This country's got problems. What are you going to do about it? Now, my friend Ernie talked about James Madison and Federalist 51. He was 37 years old when he wrote it. He inherited 100 slaves, and he died with 100 slaves. So he wasn't doing a lot of heavy lifting. He was sitting on the plantation. He was writing up these theories about separation of powers. None of them did he follow if you read his biography, as opposed to his fancy words. He was a politician from the beginning. He was manipulating. He was moving. He lied so often to George Washington that George Washington wouldn't speak to him. wouldn't invite him into Mount Vernon. He's a member of his cabinet. James Madison, he was a Jefferson guy. He wanted to make sure Jefferson president was his campaign manager. He was the Steve Bannon of his day. He was. And while he did it, he smoothed out in such a way that, guess who came president after Jefferson? James Madison just happened to become president after Jefferson. He lived to be 80 years old. He kept changing the notes of his alleged contemporary notes of the Constitutional Convention to make himself look better. When he died, he didn't free any of his slaves. So don't give me James Madison the idea that political parties just somehow miraculously appeared after the Constitution. He was an active participant in every bit of it. And when his former friend Alexander Hamilton was murdered by his wingman, Aaron Burr set him up with Dolly Madison, in case you didn't know that. He didn't say anything. His only reaction was, I hope that doesn't inspire the Federalists. Alexander Hamilton was murdered. So let's not sanctify our founding fathers as we respect them. I have deep respect for our founding fathers because they created something out of nothing. It's extraordinary what they did. It was extraordinary. And they kept at it, and they kept at it, and they wanted to make a government, and they were figuring out how to do it, and how we're going to get votes, and how is this all going to happen. I have such respect for who they really are and what they really did. Does that mean I want to go back and check every little script that they ever had? And after a couple glasses of Madeira, they sat down and wrote, what's the intent of this, that? Come on, let's get real here. That's because that's my perspective. I'm trying to be a real problem solver. Now, I'm probably the only person in the room who personally drafted a separation of power provision in the Constitution. Probably, maybe someone else, but probably not. I was a year out of law school, so naturally I could draft the Constitution, right? The Constitution of Maine. It had been in the Constitution since 1820, and I didn't once check with the intent of the founding fathers of Maine, nor did I check with the common law, nor did I check with their English ancestors. We had a problem, and we solved it. And it passed with 2/3 of both houses of the legislature. It passed by the voters of the state of Maine and has worked for 50 years because we had a problem and we solved it. That's what we do if we are human beings. So let's talk just a bit about separation of powers. We're obviously worried about protecting people's rights and powers, but which people? Which people? Remember, I told you I represented a hard-scrabble district before we had the ocean. When people died in industrial accidents, those people had liberty rights too. And then the industrial state came in, the administrative state, which is the evil. Speaking of the administrative state, I have 8 grandchildren. One of them had a car accident the other day on their way to class. She rear-ended the car. Guess what happened? The airbag went off. She walked away. She went to dance class that night. The old administrative state forced those airbags into those cars. If you think that market forces were going to say, oh no, someday cars will put airbags in because it will be in their economic interest, then you are living in dreamland. You're living in a dreamland. There's an elevator in this building. So the people who are disabled can go up to all 5 floors. You think that just happened? Do you think Harvard said, I really want to put an elevator in that building? No. No, it might ruin the architect. We don't want to do that. Right? And we're Harvard. We can do what we want. Sorry, you put an elevator in. That's the way the world works now. So let's talk about separation of powers. One of the problems we have when we talk about separation of powers and all these theories is the Supreme Court's over here doing other things without any real knowledge of state government. They have no knowledge of state government, especially Sandra Day O'Connor and David Souter left. These people have no idea how state government works. And so they say, well, we should let Congress do these things. Well, Congress did do these things. They passed something called McCain-Feingold. We had campaign finance laws in every state in the country, and they were transparent. I ran for office. I told people where my money came from to run. I actually also put my income tax returns, filed them publicly. Didn't have to. I thought transparency was a good thing. You don't have to do that now. That's all gone. Dark money is the rule. Supreme Court decided over here. So we sit over here and talk about separation of powers, in the House and horizontal and vertical and the thing, all of which is true within this silo. But the real fact is the Supreme Court, by making a decision, has turned governance over to billionaires in both parties. They get to decide. They get to decide who runs. And why is it easier to not have gridlock in state government? Because everybody's all lined up. They're either all red or they're all blue. And when the word comes down, that's what you do. That's what you do. You can move the law of Tennessee really fast right now. You just decide to do it, boom. Jurisdiction comes, jurisdiction goes. And Sarah sits on the court and says, well, the legislature did it. They don't have that gridlock problem. Yeah, pretty easy, right? So let's get real in our discussions. We could talk about many, I've got dozens of issues I could talk about, but I'm just going to talk about one. And the reason I chose it is because it's going to rain 1.5 inches to 2 inches in Maine. So I'm going to be out of here. I'll be gone by noontime. On a train back home. A federal government train, by the way, run by the administrative state. But I got a senior citizen discount and I'm going to be home. I'm here on my own nickel. I pay for my own dime. I pay for my own hotel room. So we'll talk about the Clean Water Act because it's going to rain. Now, you may or may not have noticed, because I know judges don't even read the news. They don't pay attention. They only pay what's in the briefs. You may have noticed we've got some flooding going on. You may have noticed that. If you lived in Maine, you had to take a canoe to get to Whole Foods store a couple weeks ago. It's a true story. We lost the last storms. We lost between 15 and 32 feet of dune frontage in Maine, which you'd know if you read the Bangor Daily News, as I do every day. That's a lot. That's a lot. If you read my colleague Susan Crawford's book about Charleston, she says 300,000 people are going to have to move from Charleston in the next 15 years. How are we going to do that? Don't give me separation of power. How are we going to do that? That means people need schools, they need houses, they need health care. How are we going to do it? The Supreme Court's reaction? Well, they looked at the wording of the Clean Water Act, which, Justice Alito said had been a great success, but I didn't like this unfortunate footnote to this success story, according to Justice Alito. And so we changed the words. Congress didn't change them. They've been there for 50 years, but they changed the words and left 50% of the wetlands, the number one guarantee, the best flood control you could ever have is nature's protection. Oh, we left 50% of them out. We got rid of them. Boom, 5-4. We don't need that anymore. We don't need to regulate wetlands. We'll leave it to the states. The states, the aforesaid states, the states where there's no gridlock, the states where developers and people who don't want their people who own property, whose basements aren't flooded yet, people who won't have to move yet, but if they do, they'll have the resources to move. Unlike the 300,000 people in Charleston that Professor Crawford talks about who are low income, people who work as chambermaids in those fancy hotels in downtown Charleston. They're the ones who are going to have to move. Now, I personally don't care whether the federal government, the state government, the county government, philanthropy, municipal government solves this problem. You are going to be part of that solution. And if you were not, what are you doing here? So I'll close with this. Oh, and by the way, 5-4 decision, 2 of the judges, Justice Thomas, Justice Gorsuch's mother who ran the EPA, and you might want to look that one up. They think the whole Clean Water Act's unconstitutional. They're back talking Plessy Ferguson time. They're back there early 19th, early 20th century. We don't need this at all. But we got the liberals on the court, like Alito said, well, we don't want to do that. We're just going to take care of the wetland problem. We don't want to take care of the whole thing. So let me tell you about one of my heroes, Benjamin Franklin. Because he was old. He was old when it came to the Declaration of Independence, the Constitution. Benjamin Franklin, he was a loyal. I read a lot of biographies. I don't read a lot of law. I read a lot of biographies. And Benjamin Franklin lived on 32 Craven Street in London for about 35 years with a landlady, Mrs. Stevenson. And one day, he walked to St. Paul's Cathedral. 1769. Have you been in London? Have you seen St. Paul's Cathedral? It's an astounding dome. It is an astounding piece of architecture designed by Sir Christopher Wren. It is beautiful. But when Benjamin Franklin went there, he didn't step back the way I did and say, wow, it's beautiful, and I want to climb it, which I did, which is probably silly for somebody my age, but I did. He looked up and he said, you know what this place needs? Lightning rods. Lightning rods. He goes in to see the rector of the church. He says, I'm Benjamin Franklin. He says, oh, Dr. Franklin, we know all about you. Well, you know about the tent and the kite? Oh, yeah, you're an expert. If you don't have lightning rods up here, this is going to burn down. And the rector said, well, you know, some people think lightning came from God. Listen, it's electricity. It's going to burn down. It's going to burn down. And so he got himself on the committee. He was smart, didn't make himself the chairman. And 2 seconds on Google, you could read the committee report. And they got lightning rods that lasted from 1769 to 1929 before those lightning rods came out. And all of us and our children and our grandchildren can go and look at that because he solved a problem. And I'll tell you, my young friends here today, this country can burn down. You've got to find the modern day lightning rods. That's your job. Thanks.
I don't know if any of the members of the panel have some things they want to say in response to lightning rods or anything else before I start posing some questions.
I'll give it a shot. I think a lot of that is very wise and very helpful, but I just don't think it's contrary to a lot of what we're saying. So Madison, for instance, I'm not sanctifying Madison. I think Madison is saying, don't sanctify me. I think one translation of Federalist 51 is trust no one, right? You put the equal and opposite opposition of vice together to create a separation of powers. Men aren't angels. You have to count on their selfish desires, and you try to contain them in some way by structuring the government. I think the idea is to be realistic about politics, to not put anyone on a pedestal, and try to deal with the sort of politicians that we're likely to have. Don't be academic, right? Be practical, solve problems. I think one virtue of the states is that they're not technocrats in an agency pursuing some academic vision, that they, Lena Khan at the FTC, for instance, has her theories about competition that she is implementing in an agency. States are complete governments. They're responsible for keeping the schools open, keeping the roads passable, responding to disasters, all these things. And so they have to be a little more pragmatic about things. They can't afford to be ideologues, and they can't afford to be academics. I think. Be realistic, try to solve problems. I think that the states are the only governments that are themselves going to be held accountable when they don't meet certain responsibilities, and I think that introduces a certain pragmatism into their politics that is salutary. So I take all that on board, but I don't think we should sanctify the federal government either. I don't think we should assume that they'll always be the ones that are going to get the right answer. We've had governments in this world that had an impressive array of individual rights guarantees, but were prioritized around just doing whatever you need to do to solve problems. The USSR was one of those, right? They didn't have a lot of structural constraints that got in the way of solving problems, but they didn't always choose the optimal approach for people, right? What they didn't have that we have is separation of powers and federalism, and those things get in the way all the time. But because we trust no one, because we don't count on anybody being perfect and virtuous all the time, we're not putting all our eggs in one basket. And I think that's what federalism at the end of the day is about being realistic, that one person isn't always going to have all the right answers, and we should always require a multitude of people to agree before we do anything drastic.
So, have any other responses? Okay. Well, let's talk a little bit about cooperative federalism, Professor Young. So one response to, we need to do more stuff is that the federal government gets out its fire hose of money and sprays money at some of the states, and then we get some joint federal state task forces and things. And, in my own field, criminal justice, we get sometimes you get some good cooperation across jurisdictions, and then sometimes you get, let's turn over the surplus military equipment to these states so that you get the the small-time police chiefs riding around little tanks and using SWAT team tactics to break down the doors of suspects and stuff. And so sometimes the desire to have, energy or overcome the limitations of states can lead to vigorous enforcement, but vigorous enforcement is not always what we want. How do we keep the good of cooperation while keeping some, as you said, uncooperative federalism, some limitations that keep them from circumventing state limits? I mean, I know one thing that has happened in a lot of states in criminal justice is states have tried to put limits on the abuses of forfeiture laws because the police departments profit from the forfeiture laws, and they then spend their time targeting the lucrative crimes, not necessarily the dangerous crimes people are most concerned about. And so some state police circumvent these legislative limits by going to the feds and having the feds do the forfeiture and then getting a kickback of 80% of the money from the feds. And so by trying to get stuff done and having the feds evade this state limit policy on creating bad incentives for forfeitures, you wind up recreating some of the abuses. So what does uncooperative federalism need to look like to preserve the good of those limits, but overcome the, Mr. Tierney makes the point about there is inertia, lack of capacity, et cetera, that prevents states from solving problems. So talk about the trade-offs there, Professor.
Well, one of the problems in law schools is we only teach the fights. Right? We don't talk about when it works great. Let me give you an example of where it works great. Since 1952, the federal government has sent money to state fish and game departments in order to help manage fish, right? They just send the money, and then state money put in. So I researched one pond in Maine, Bryant Pond, to get ready for our little talk today. And we were having trouble with the brown trout and the landlocked salmon issue, but federal government came in, state government, philanthropists, and it worked, and nobody complains. As a matter of fact, Bryant Pond's most famous resident, Tucker Carlson, brags about the fact that those fish are just great. He just loves the government. He doesn't even know that the federal government, the state government, the local government, the fish and game wardens are the ones that allow him to go out there in his bucolic world when he's not hanging out with Putin and fish. He doesn't even know that. So cooperative federalism works every day. This train I'm going to be on is federal, but I'm paying to get on, senior citizen rate, but I'm paying to get on. And so, the local towns along the way, they did all these other things, they work on it, and it works. So we only talk about the fights, and then we elevate the fights when someone suddenly cares about fish. The Koch brothers care about fish. I don't understand this. They want to change the whole administrative state because they're concerned about some fishermen, which of course is clearly not true. But that's the myth that we all walk around and try to pretend is true as we give more and more power to the Supreme Court. But I think one of the answers, Your Honor, is to not fall into the trap of only looking at the problems. You're right. You're citing abuses. You're citing problems. And believe me, I'm very familiar with the issues about forfeitures and all of that stuff. I live with it. But it really works. Cooperative federalism works. Let's not try to draw the precise lines. God help us if we have a vague law. They were kicking vague laws around last night at the conference. Oh my God, did I write a vague law once? I probably did. Shame on me. You had the judge, lifetime job security, and the professor, lifetime job security. Those vague laws that those people pass. I'm sitting over here with Sarah, and I'm going, oh God, hope they didn't catch one of my vague laws.
I think that's absolutely right, that it often does work. And I think the reason why it often does work probably better than it would if the federal government had the power to just mandate what state and local officials are going to do is that they kind of negotiate in the shadow of the fact that Congress can't compel, but at the same time, the states could really use the money and would like to have a say in what's going on. And so they have strong incentives to work things out. And I think they usually do work things out. And that's absolutely right. And I think one reason why they work things out most of the time is also that many of the people involved are politically accountable. So I would think the ultimate checks on, for instance, taking a bunch of tanks from, Army surplus and using them to enforce criminal law in Henderson or something like that in violation of the wishes of the community, is that the officials who made that decision are going to be politically accountable and eventually are going to pay a price for that. I mean, there are some ways in which you might put limits on the spending power. You might limit the ability of Congress to kind of target and drive a wedge into the state separation of powers by dealing selectively with one level of government or with one branch of the government. But mostly that's going to be a matter of state separation of powers law, whether they want to allow that or whether they want to have a more unitary executive or something like that. But really political accountability at the state level. But I think there's a lot of that.
Do you think anti-commandeering is a meaningful part of that? Does it mean much in practice to prevent the feds from telling state agents to do things?
So I used to think that it didn't make much difference because if you look at the facts of New York versus United States, it's a very, very strange statute. And if you look at the facts of Prince, it's a very, very minor statute, right? It's the temporary provisions of the Brady Act until the entirely federal system gets up and running for gun control. But I think it creates this basic idea that the state and local officials do not work for the federal government. That's the anti-commandeering doctrine. That's what that means. And I think in some ways that's the only kind of state sovereignty that is left, right? It's not an exclusive zone of regulatory authority. Certainly, it's the fact that we have our officials and they're theirs. They work for us. And you can try to persuade us that we should help you out. And generally speaking, we will, because it will be in our interest. But the anti-commandeering doctrine is what frames that conversation and requires Congress to give something when it does and to be reasonable.
And I think the anti-commandeering doctrine is, of course, also very important with respect to political accountability, which you mentioned. I mean, political accountability is, I think, essential if we're going to have these sort of cooperative programs, and to know which officials should be politically accountable for certain decisions. I mean, that's another way in which the anti-commandeering doctrine steps in, because it prevents, I guess, the responsibility from being so ambiguous or diffuse that that the electorate doesn't know whom to hold accountable in those situations.
But this is dreamland stuff. There's no politically accountability when the billionaires are telling you who you're going to vote for. You live in Tennessee. Nashville has always had a Democratic congressman until this redistricting. They divided Nashville up. They will never have a Democratic congressman again. Ernie, you live in North Carolina. 3 Democratic congressmen quit. They said, there's no possible way I can win this election. I've been gerrymandered out of existence. What are we talking about? Political accountability. And it goes right down to local school boards and legislative races. Who is kidding who here? Let's get in the real world. There's no accountability. It doesn't make any difference who you vote for. For a lot of people, it doesn't really make any difference. All the fights are in primaries. Why bother? Why bother? I talk to congressmen all the time. They say, why am I doing this? It doesn't make any difference if I don't come, someone just like me who agrees with me on everything, because they're going to take the party orders, they're going to vote exactly the same way I do. And the end result is we don't send money to Ukraine, something that this country wants, desperately wants. We can't figure out how to do it. That's not political accountability, and that's true right down to school boards. It's right down into law schools, where I see my students lining themselves up right away and afraid to say anything in class because they're afraid that someday it may cost them a judgeship. I see it every day. They tell me privately. It changes the way I teach. I have to teach using hypotheticals and order my students to say things because they're afraid to say what they really believe, even in an academic institution. So let's not pretend that we don't have serious accountability problems by chanting 17th, 18th, and 19th century political theory when the Supreme Court took care of all of this by eliminating campaign finance law, eliminating transparency. You want to have political accountability, have transparency where the money comes from. We don't want to do that. I like it the way it is.
So what's the answer, though, right? I mean, this is the counsel of despair. And,
it's not
and so you want all these people to go out and solve problems,
Look, I'm
right?
glad Tucker Carlson's catching those fish. I don't have any despair. I'm glad he's here. I hope he pays his taxes.
He should
That's all
be
I got. Leonard
fishing.
Leo lives in Maine too. They all live in Maine. They love the views. They love the environment. It's all great. It's all great. They have their parties there. It's great. Everybody loves to go to Maine. About a third of the Harvard faculty, I think, live in Maine. I see them all the time. Right? Everybody loves Maine. Well, when you get to be a little senior, you make a few more bucks, you come out and join the senior faculty. The answer is democracy. The answer is to dig into your communities and to care about your school boards and to care about your legislators and to buck this terrible trend and to maybe, just maybe, keep fighting back. That's what you've got to do. It's our country. I mean, that's why I love the Founding Fathers. They fought every day. They fought every day for what they believed in. And look, I understand my audience here today. You're not going to agree with a lot of the things I'm going to do. So what? Go do it. You're young. I'm old. You know, I'm going to be gone. I don't have to worry about the 300,000 people who have to live in Charleston. Why? I live in Maine. That's why.
So, Justice Campbell, states have very different separations of powers, and your state's unusual in that your attorney general is not part of the executive branch, part of the legislative branch. Used to
Part of the judicial branch.
judicial branch. I'm sorry, used to work there. How do these design choices make things work differently in a state like Tennessee?
We are very unique in our design. So Tennessee is the only state in the country in which the state Supreme Court appoints the Attorney General. So our Attorney General's office is part of the judicial branch rather than the executive branch or the legislative branch. I think historically that has led to a couple of differences. I think, first of all, for many years, because the Supreme Court appoints the Attorney General, for a number of years after the legislature really shifted to Republican control in Tennessee, we still had an Attorney General appointed by a Supreme Court made up of justices predominantly appointed by a Democratic governor. So there was a sort of divide in political power in that respect. But also, I think the fact that our Attorney General is not elected and is not politically appointed has caused that office to be a bit more stable than other offices. We have not had any attorneys general run for governor, to my knowledge, certainly none that won an election for governor. Our attorneys general typically do not go on to seek further, any sort of elected office. So we've had, I think, a more stable staff in the attorney general's office, more career folks rather than political folks. So. And I think less involvement historically, and this has begun to change, but historically, I think less involvement in multi-state litigation that, could be said to have, some sort of political tilt. Less involvement, perhaps in amicus briefs, that sort of thing. So in multi-state coordination, but more of a leadership role, I think, on issues that had a lot of bipartisan support.
There's bipartisan support, such as your Attorney General who signed the brief to overturn the presidential election in a lawsuit that was thrown out 48 hours by the Supreme Court, Texas person. That's a really non-political Attorney General of Tennessee, Sarah. I mean, what are we talking about here? Let's get real. I just don't like the fantasy. Your Attorney General has gone to the legislature to ask for additional staff because his career staff, the stable staff you were talking to, won't represent him on some of the cases he wants to bring. He's quite open about it.
Well, the dynamics, if I may interrupt for a second, I mean, the dynamic is changing, and that's why, my discussion was really talking about historically what the office has been. And I think there are a lot of those features that do still exist, at least exist more than they do in other states. But, I think as the Attorney General role nationwide is changing, and you're seeing more multi-state litigation, you're seeing, more involvement in challenging federal rules, that sort of thing. I think there has been, more interest, certainly among our state legislators, in having an Attorney General in Tennessee that takes on that role. And it is, I think, it certainly is changing. You're not wrong that I think the office today has a
EPA
different...
Massachusetts gave special standing to state attorneys general to challenge, and so every attorney general now feels it's part of their job to challenge rules that come from whoever the president is that they're not in office for. There's nothing magical about that. There's nothing based on the separation of powers. You know, they just made it up. In EPA versus Massachusetts, we'll give the state special solicitude. It wasn't even briefed. They just made it up. You know, I mean, why again? Why can't we be real? Why do we have to pretend, cover it with all this legal rhetoric when it's clear what it was? That's where it came from. So now it's part of every AG's job to challenge the president. It's not in your office, even the appointed AGs like the ones you have in Tennessee. Let's go try to overturn the presidential election. What the heck? Right?
I think that
Appointed AGs go to, your attorney general goes to Republican AG meetings. Republican AGs Association, founded by who? That nonpartisan judge, Bill Pryor, when he was attorney general. He founded the Republican AGs Association. We didn't used to have partisan organizations. He thought it was a great idea. He and John Cornyn, they said, let's do that. Most of the Republican AGs didn't want to do it. They said, don't do that. We don't want to have partisan, we want to be nonpartisan law enforcement people. Bill Pryor, another approach.
So I'm not, if I may just add one point, I'd actually be interested in your thoughts on this. I mean, I'm not denying that there is a lot of that sort of litigation going on around the country, but there are still many areas in which there is bipartisan cooperation among attorneys general. So one is opioids, for example. The big tech cases.
Antitrust,
very
tech,
bipartisan
consumer protection, correct. That absolutely correct. And if the core philosophy of state attorneys general wasn't functioning, I wouldn't be teaching it anymore, all right? I do believe in that office. I do believe it should be independent from the executive. I think when the attorney general can be appointed by the governor, bad things happen. Bad things happen. People get prosecuted who shouldn't be. People are given passes who shouldn't be, and it's not based on the law. I think it's a core duty, and I'm thrilled that in Tennessee and in all but 2 states, the AG is separate from the governor. But that's what I teach. You know, I didn't come down here today to teach my class. You know, but I had a student here who stopped me last night. You know, after I was leaving yesterday, worried about what vague laws I'd written, and I was kind of in the dumps. So one of my students stopped me on a Jan term. We have a 3-week Jan term, and he went to his home state, and he actually worked in an AG's office, and he said, "Wow, that's terrific. That's real stuff. That's dealing with real cases, even though it was only 3 weeks. Yeah, I might do that someday." And that's what keeps me coming back. So I believe in that. I believe in state law enforcement. I believe in separate. I believe in prosecutorial discretion. But I can see these winds, these powers are coming in from the outside, and most of them are driven by the U.S. Supreme Court. It says, we don't have to regulate wetlands anymore, and we can knock down campaign financing laws, and we can just do what we want. They have standing. Standing's like an accordion. It opens and it closes depending on what the judge wants to do. It's open, it's closed. I mean, we know that. Right? We know that. In the real world, I'm watching out here, and I'm getting a lot of nods from people. They're going, yeah, this Tierney guy, you know, I don't know where he went to law school, but I'm telling you something. He's telling me the truth because it resonates with my own life. You're smiling. It's great. I'd love to have a smiling audience. It's great.
So far, we've been focusing on the division between federal and state power, but we often forget that there are multiple layers of power, and the lack of coordination can sometimes cause problems. In criminal justice, it's you know, we have policing at the city or precinct level and prosecuting usually at the county level, usually separately elected by each county. There are a handful of states that are exceptions. And then, you know, prisons paid for at the state level. And so for a while, this has been known as the correctional free lunch problem, when the economists will say when the marginal cost is zero, maybe you wind up overusing things like prison beds. There are some interesting state experiments. California's been doing this thing called realignment to try to internalize some of these costs. But there's also friction. You get state attorneys general and, you know, with overlapping jurisdiction, because the county DAs are also prosecuting in the name of the state. So how does that, you know, that friction can be a productive thing, but it can also look like an extremely messy thing. People from non-federal systems look at this and say, like, where is the power?
Again, the friction, you only hear about the friction when it doesn't work.
Right.
All right? When the appellate division says to a DA, don't bring that case, it's a weak case, or don't argue those things, you don't see that. You only see the better results. So I like the friction. I think it's an appropriate check and balance. It takes care of conflicts of interest. When the DA has a conflict, they need to have a place to go to. The question of the police misconduct, I think oftentimes appropriately resides in the Attorney General's office because local prosecutors are dealing with those police officers every day. I think it's a good structure. It's a good system. But you're correct. You're watching where it doesn't work, right? And that's your job because you're a judge. You only feel the pain, right? You don't see it when everything's working smooth.
Justice Campbell, let's talk a little bit about the state-federal court interaction. You were talking about, well, maybe they don't certify cases enough. From my perspective as a federal judge, we're concerned, lest we certify cases too much and tax you. But certification is the only kind of formal mechanism by which we talk. And, obviously there's habeas, but that's long drawn out, many years after conviction. What kind of coordination is there or can there be between the federal and state judges in an area on areas where we really are supposed to be following your lead in diversity cases? And yet, jurisdictionally, a lot of common law, contract, tort cases wind up in federal court because of arbitration and class actions, et cetera. And do we bug you about each one of those things? How do we know what's the right way to handle some of that?
I think it's very important that a dialogue occur. And I think sometimes that dialogue can be in decisions. I think state courts can do a better job of indicating to federal courts, when we want issues certified. There might be particular areas of the law that, because of things like the Class Action Fairness Act, predominantly end up in federal court instead of state court, and that really can impede the development of state law. So we might, when the opportunity arises in one of our decisions, drop a footnote that says, or if you don't like footnotes, Judge Pryor is not a fan of footnotes, you could put it in the body of the opinion also. Then, I think that's perfectly appropriate to just indicate if there are categories of cases or particular circumstances in which certification is a good thing and in which we would invite that. At the Sixth Circuit Judicial Conference a couple of years ago, I was very pleased that Chief Judge Sutton, I think, invited all of the state court justices to attend from Sixth Circuit states. There was a panel with chief justices from all of the Sixth Circuit states talking about this very topic, certification. That's a terrific opportunity to get a sense of what a state Supreme Court's philosophy is on certification. My court is quite open to certification. Not every state court may have that perspective, and it may be true that for some states it would be annoying to the court to keep sending it, questions. My view is the worst we can say is no, and at least we're given the opportunity to decide whether that's a state or that's an issue that warrants my court's attention. So I think that dialogue can occur in a few different ways, both formal and informal, but it's really important that it happen.
So I know I don't get to call on Justice Campbell anymore in the old way, but I do have a question, and that is, you talked about how state courts might think of their role as different, right, from federal courts. And this is something I've been wondering about for a long time because, in con law, we talk about the counter-majoritarian difficulty in Alexander Bickel, the courts don't have a democratic mandate to match the legislature, and so how can they overrule the legislature in a democracy? And so I always wondered, well, if I'm a state judge and I'm elected, do I just say, yay me, I don't have any counter-majoritarian difficulty. I can make up a right to privacy. I can do all kinds of fun stuff. And I asked this question to my students. We have a judges program at Duke that meets in the summer. We have both state and federal judges in the program. And I always ask them this, and they kind of look at me like only an academic would ask that question. And so they seem to have kind of the same idea of a judge, at least most of those state judges that I've talked to. Do you think that's different? Do you, as you've done this job longer, are you starting to kind of spread your wings and make some law and that sort of thing?
No. But there are certainly state judges that I think would take the view that being elected either, so I think there are really two factors that could play into a state court judge's view that they might have more democratic legitimacy. So one is the fact of their election. But the second is one I mentioned earlier, and that is the common law decision-making authority that state judges exercise. There are lots of state court judges who, I think that the common law decision-making really is policy-making. I disagree with that. I think that common law adjudication is really about, case-by-case adjudication of an application of a settled body of common law precedent. But to the election point, look, you have to ask the question, to what position are they being elected? The mere fact of election does not give someone the license to make policy and to make law if that is not the position for which they are being elected. So I think any discussion of the role of a state judge, has to consider separation of powers principles and how those principles constrain the role of a judge. Now, those principles, right, may vary among states. States allocate power among the branches of government in different ways. But in Tennessee, the power that is given to the judicial branch is the judicial power. And the judicial power has to mean something. And my view is that in light of the separation of powers, being elected to be a judge and to carry out the judicial role means that I have the authority to adjudicate cases that come before me and to interpret and apply the existing law and not to make law or, divine law from some source outside of the written law, whether it be statutory law or kind of customary common law.
Professor Brady.
Yeah, can I ask one, or can I put one final thing on this before if there's another question, which is about, since especially I'm speaking to an audience of students and another of my gigs is local law and state constitutional law. I think for state judges to play a different role, they need state lawyers to raise claims and press arguments that are different or that push the envelope. And I think a frustration of mine is that you all are taught federal is better. We should all try to be federal, bring federal claims, and not so much of the state constitutional stuff, including, in the federal con law course. I don't know how many of you had a state constitutional case. I would venture not very many. And so for, I think, state judges to have the potential to have a different role or to have the kind of dialogue that I think several of us at least view as beneficial, those claims need to be made by you. And partially our law school curricula are a little bit of a failing in that regard and encouraging you to pursue those kinds of claims.
All right, Professor Brady, in your bailiwick, property law, classically a common law subject, at the time of the founding, there's this understanding of general law out there. And so we don't really need to focus on differences among property law, one state to another, or federal versus state. And then, of course, and through Swift versus Tyson, that's how it's being applied. But post-Erie, where we think it's all positivist, how does the positive law model differ when we have, the feds overlaying these takings claims or Fourth Amendment claims on top of them? And are the takings rules or what searches and seizures are permissible going to vary from state to state depending on the status of lessees or visitors or people who borrow a car? I mean, there's going to be inconsistencies either way. What's the lesser of the two evils here?
Yeah, I think it's a really hard question, sort of like what level of variation is desirable. Just a note on general law. I think even my good general law friends like Steve Sachs and Judd Campbell, I've asked them about what they think about property law as sort of general law, like was there a general law? And they say, well, there's a general idea of property that's filled with content from local and state groups. So even in the sort of heyday of general law and way back in history, it's sort of a local thing. And some of what led to Erie was sort of the expansion of general law toward property that everyone perceived as wrong. So I'll resist the hypo just a little bit. I think in the context of variation or deciding what level of variation is appropriate, I do think context matters. There may be reasons, for instance, that in search and seizure law, we might worry a lot about differences in whether something is a search depending on state-specific tort law such that you get a different Fourth Amendment outcome if you're in Southern Mass versus Rhode Island. There may be sort of like arguments for homogenization. But with respect to land law, I do think, there's a lot more a lot more stickiness, the buy-in of being a landowner or living somewhere, and being aware of and having your expectations shaped by local law that may not be as true when it comes to criminal law, given again sort of the buy-in required to become, in some cases, a property owner. So I guess I still think that in takings in particular, there's value in variation. I mean, generally, I'm a little bit of a fan of mud, both property and just like muddy rules. So I like that there's sort of innovations in property forms and coverage and different sort of ways of testing out. I think this sort of laboratories idea about what is the best solution to a problem. We tolerate variation in things like adverse possession and nuisance and public nuisance and all these other concepts. And so to me, it sort of makes sense to have it at that level too. But I don't know that I would hold that constant across all the different parts of the Constitution that make reference to state common law.
Were you implying earlier that thought the U.S. Supreme Court had been forcing too much uniformity in takings cases?
I think so, yeah. And it's kind of, it's coming from a couple different places. Again, it's a sort of starting point, which I think is very consistent with a lot of other things the court is doing, where it's sort of broad history, tradition, kind of general ideas, as opposed to what I think of as an older tradition of hewing more closely to the states. There's a famous case called Lucas versus South Carolina Coastal Council. It's about whether a wetland regulation is a taking. I'm sure my co-panelist has thoughts on it. In that case, it's interesting to me that Justice Scalia, despite sort of announcing a new takings rule, remands to the South Carolina courts to basically apply the analysis. And so there's sort of a deference there that I think is just less prevalent in these recent decisions.
All right, we have some time for some audience questions. Please, if you take a mic, stand up, identify yourself by name and school, and ask a question. 3 sentences maximum. There should be a question mark at the end of that.
The odd law professors, you don't have to worry.
Thank you, Professor Tierney, for your performance. I'm Luke DeWeese, and I'm at Penn State Law. I'm pretty sure I'm the only one here from my local FedSoc chapter. So I would, I mean, I appreciate your kind of, the way that you clearly teach, keeping it very kind of flighty and very amusing. I like this. The problem is, how can you say that the Founding Fathers are cool because they created a new government out of nothing? Like, this completely disregards the pre-modern origins of American law. How can you say this? And I say this with a PhD in medieval studies.
I'm sure you do. I have a daughter-in-law who's actually at Penn State Law. She has a PhD too, so there you go. As a matter of fact, I've got 3 unemployed PhDs who also went to law school who are calling me up, and they're trying to get jobs in AG offices. I'm serious, I got 3. One of them's living with his in-laws. It's bad, man. It's like, they all want to help AGs with policy. I've got my PhD. I want to help the AG with policy. AG, I mean, I think, Sarah, you and I would agree.
Sir, that's a grave distraction from the question at hand, sir.
Which is why I'm saying, I don't understand.
That's an ad hominem circumstantial, and it's insulting.
I don't understand your question. I'm sorry.
How can you say that the Founding Fathers created a new government out of nothing? How can you say this? This completely ignores the pre-modern origins.
They made Montesquieu.
What did you say? They got it out, the habeas corpus came from nothing? That it wasn't borrowed and inherited from the inherited tradition? How can you say this? This is just rank error.
I don't understand your question. Okay, maybe I'm wrong. Maybe it is. That's easy. You've convinced me. Nothing like, you cannot talk to a lawyer who also has a doctorate degree and win. I'll tell you all about it sometime. You can't do it. I have no idea what your question is.
All right. Next question. Oh, over here? Yeah, I see a hand.
We need a microphone.
We've got to bring a mic.
It's a boundary problem.
Hi, thank you all for being here. I know I speak for everyone, and I say it's a real pleasure to hear you all debate. I'm Matthew Stanko from the University of Maryland undergraduate chapter, and my question is for Justice Campbell. What exactly is the process for certifying a question to the Tennessee Supreme Court? Is it something made... Sorry, I think this has gone out. Is it something made on motion from one of the parties, or is it sua sponte from the court? What exactly does that look like?
So in the federal court, the federal court can do it sua sponte. The federal court can do it at the request of a party. I'll note that it can be done by the district court. It depends on the state's certification rule. In Tennessee, our certification rule allows a federal district court, a federal appellate court, a federal bankruptcy court, or the U.S. Supreme Court to certify the question. And a lot of other state certification rules are similar. So it's initiated by the district court either on its own initiative or at the request of one of the parties. And then that request goes to the state's highest court. So we consider a Rule 23 certification request, just like we do other applications for discretionary review. So our decision to certify is a discretionary one. We don't have to certify even if it meets the criteria for certification. And this may be the case that states need to look at their certification rules. Going back to the Lindenberg case, the reason that the Tennessee Supreme Court declined to certify when it was initially certified by the district court, or declined to accept certification when it was certified by the district court, was that the certified issues were not determinative, or at least it wasn't yet clear that they would be. So it may be that states need to look at relaxing the criteria for certification in order to get questions certified with more frequency.
Hello, thank you all for coming. My name is Anthony Leonardi. I'm from the South Dakota chapter. My question is for Mr. Tierney too. I'm actually very sympathetic to your criticism of like navel gazing tendencies. My goodness, it's the morning. In fact, it made me think of the Oppenheimer quote of "Theory will only take you so far." But my problem with that is that line comes from the context of what happens if we set off a nuke, will we explode the entire Earth? So as somebody who comes from the perspective of valuing some academic discussion to discuss principles, so you're fixing your attention on an ideal, so your decisions that you take you to a more perfect state of affairs, how would you suggest morphing the two of if you appreciate the kind of academic discussion on separation of powers and then taking action? How would you harmonize them?
Well, I've spoken too much, but I am going to say this. I have succeeded because I have you thinking about this. This means I did a good job today, and I hope you're not the only one who's thinking about this and wrestling with it. Thanks for your question.
All right, over here.
Hi, my name is Jose Cosme Guerrero. I come from Dallas, from Southern Methodist University. The president of our chapter is over there, and we are very thankful for you guys to let us be here. My question is about Citizens United. I'm a foreign trained student. I come from Mexico. I'm an attorney for 20 years there, and I'm doing an LLM. And it's very curious how the First Amendment was enlarged to protect companies and their interest in the voting and money and the funding. My question is for Mr. James Tierney. Yes, of course. Because what kind of political environment or social environment would we have to foster in order to overturn Citizens United? I think, in my personal opinion, that it is very dangerous.
Is there a connection to federalism and the separation of powers here?
I don't know, but I would like to question that. Yes, thank you.
I didn't understand this question.
All right. Do we have a federalism question?
Hello, I'm Thomas Slanover. I'm from the evening program at Fordham Law. I guess this is for Professor Brady. In light of recent public nuisance claims on environmental issues, do you see that novel public nuisance claims can basically be a proxy attempt at state-federal regulation?
Yeah, I mean, public nuisance as a whole raises really fascinating federalism problems. You could do a whole separate panel on, some of the cases being brought as public nuisance cases as an effort to influence national policy. So it's a very, very interesting topic. I think this is an example to where if it worked ideally and wasn't sort of being used to address, I think, large national problems to the extent it currently is, we might be able to address smaller problems with better law. So the other thing I'll say, relates to, I think, some of the earlier questions about in my thinking about public nuisance, which is I'm a little resistant, perhaps predictably so, to the sort of academic practical distinction. I think public nuisance is a good example of that, where we have people who are thinking about sort of what are the principles underlying this concept. Does it have to be connected to uses of land, or can we, as one group is using it, say sue Kia and Hyundai because their cars are so easy to steal? Is there any plausible way to relate that to sort of the underpinnings of nuisance law and tort law in general? So, I think the academic discussion about that is framing how courts and how litigators are trying to bring and frame their claims. Again, I think a lot of these cases have more to do with something that's been talked about already, which is sort of AGs pursuing them as sort of national political goals, as opposed to something that is sort of meant to target state-specific problems. There are exceptions to that, and I think some interesting cases in the Southwest, for instance, that are using public nuisance where states are declining to act in a way that does sort of address more a local or a regional problem. But I think, public nuisance as a federalism problem would be a good student note. So you should write it. Congrats.
You should know one of the really hot issues that all the federal courts are grappling with are these states and localities that are suing oil companies for climate change. And they're suing in state court, and they're saying we're only seeking relief for what's within our jurisdiction. And the oil companies all are trying to get it removed to federal court. And so far they've been shot down unanimously. And so are we going to see preemption or federal tort reform of this? Or will the US Supreme Court take the issue up? But for now, it's been left. And, I and every other judge to confront the issue just left it down in the state courts, that the states ultimately have to decide what they're going to do with this, even though it's a localized piece of a global problem.
Yeah, and let me jump in. I just think those lawsuits are stupid. I mean, look, climate change is here. The question of who caused it is kind of problematic. You've got to get the major fossil fuel people into the solution here. You're not going to do that by throwing a bunch of plaintiffs' lawyers in there representing some town or city or county or state for that matter. They came to me early and I said, no, I'm out. Bad idea. Let's go solve the problem. You get a little theme in my remarks? Let's try to solve the problem here. And plaintiffs' lawyers, removal, Supreme Court. Oh my God, it's terrible. It's stupid lawsuits. Don't file them in the first place. Show a little judgment, show a little wisdom.
Well, I think just one thing on that, which is, I don't think they're even, some of the plaintiffs' lawyers, they get great fees, et cetera. So that's a different motivation. But particularly on the academic side, just to present an argument that's been made by friends, including now soon-to-be Dean Leslie Kendrick at University of Virginia, is that it's a second best solution. Like, if people are failing to act in response to a problem, why not throw
file a lawsuit? We're lawyers. Let's go file a lawsuit. That's a great idea.
Just don't solve the problem.
It's not going to work. It's not going to work. Lawyers make a lot of money. It's stupid. That's a legal term. I don't know whether you've ever heard of it.
I have one other thought on the climate change thing, which is, actually, Montana did have a recent interesting case along these lines, because the Montana Constitution since the 70s has had a provision where they recognize a right to a healthful environment. And I mean, everyone kind of laughs at this and says, okay, yes, the Montana court sort of said there's a right to a healthful environment. You can't sort of ban or you can't try to ban actions about climate change in this way, which the legislature had tried to sort of keep those actions out of court. But it is sort of a recognition of the uniqueness of the state constitution. Probably it's not going to address any global problem, but it is, I think, sort of from a signaling perspective, important.
Good morning. My name is Ben Sievert from University of Wisconsin. This question is also for Professor Brady. So there's a very recent preprint from a professor from my law school, and also that's Joshua Braver and also Ilya Somin. The article is titled "The Constitutional Case Against Exclusionary Zoning." They argue essentially that the takings clause prohibits exclusionary zoning, which is frankly most Euclidean zoning. And I wanted to know if you could comment on that and the federal concerns for suddenly creating a federal cause of action for pretty much every single municipality's zoning policies.
Yeah, so both Professor Somian and Professor Braber, who's actually a law school classmate of mine, are friends, and so I've read this article that basically makes the claim that zoning is unconstitutional, which I think is a great idea were it not for Euclid, which is a really interesting case that I also despise. But I think I don't see the courts buying their argument. I think also there are interesting articles about sort of the history of land use regulation generally pre-zoning. There are colonial land use laws. There's an article by someone named John Hart, not to be confused with John Hart Ely, on colonial land use regulation. And so there is a sort of longer history of this that I think is difficult to jam into their model. I do think that, again, this is an area where I think some of the state constitutional claims might be a better solution also because it avoids the sort of parade of horribles of turning every single zoning matter into a federal case. So the other thing I'll say is that while single family zoning is under fire, and you won't find anyone else who disagrees with that or agrees with that more than me here. There is value in things like use separation in terms of keeping people healthy and protecting people. And so I think something that would threaten that is worrisome. So I like the argument, but I think practically there's an example where I agree that maybe academia is going in a different direction than the practice.
Over here.
Hi, thank you all so much for coming. My name is Jack. I help run the University of Maryland chapter with my dear friend Matthew. My question is for Judge Bibas. Could you give an example of a case where you decided to certify a question to a state court and a case where you declined to do so and your reasoning for those decisions?
Okay, so my court, Amazon has been sued across the country for people who buy things on their marketplace. And there's this question about whether or not the marketplace is like a traditional auctioneer, in which case there's not strict liability put sold on it, or whether it's more like goods that a vendor has in stock and sells himself, in which case you can then have strict liability. And our court was wrestling with this, and most of the other courts in the country had said no liability. We had a panel of our court that found liability, and then we took the case en banc, and we ultimately decided we were going to certify it to the state Supreme Court. Now, what's interesting there, it's ultimately the state Supreme Court's job. I might not like what they're going to do or not, but it's their job to decide it. But the quirk here is then Amazon then settled the case. So the case goes away, which is an interesting way, like the precedent, but ultimately it's not our job to stick our noses in. And I know a lot of our, there are lots of routine insurance cases we get, and they're matters of state law. And what I find winds up happening in those is that my colleagues are very reluctant to write precedentially, and we just write what most courts call unpublished decisions. I'm not sure I agree with it, but the impulse seems to be that, well, we're just afraid of making law on something where we could be wrong in making our eerie guess. And so we just resolve this as a case-specific ruling, but then the problem is we're just going to have more and more of these, and a lot of insurance cases wind up in federal court. But we're very often trying to take a guess. I can think of one other case where Delaware has a law that's supposed to basically take the profit out of going and assigning your life insurance policy to someone else and getting a cash payout for it. And so they say these assignments are void, but then the person who assigned it gets to keep the money, so that it's the companies that are going around buying this up that should know better and will wind up losing money if they keep doing this illegal business in the state. And so we assigned it over to them and said, do you really mean that? And they came back yes, we really mean that. The guy gets to keep the money for having assigned his policy, and then coming back and we say it's void. But that's Delaware's public policy, and it's not for me to make that public policy.
One thing, if I could add one point on that, Erie was really designed to eliminate or at least minimize forum shopping. But one thing that can happen when a federal court, makes an incorrect Erie guess, and it might be difficult to get that issue back into state court, or one reason why it can be difficult to get that issue brought up in state court is because, let's say a federal court decides that issue in a way that's favorable to defendants. Well, defendants are always going to, remove that case to federal court. And so it can incentivize, an incorrect Erie guess can then incentivize forum shopping and make it increasingly difficult for the state court to hear that issue absent certification.
Last question.
Thank you all for speaking today. My name is Jessica Vandervoort, and I'm from Suffolk University Law School down the street. This is a question for Justice Campbell specifically. You mentioned the amount in controversy and how it hasn't really gone up in 30 years. So I'm wondering, with this issue of, again, forum shopping and things like that, do you think there will be a push to raise that cap in the days ahead? And if so, pros and cons of that? Thank you.
There have been pushes, within the past 30 years that have not been successful. And, I think the current problem is attributable both to that monetary threshold not being increased, but also, federal statutes that have eliminated the complete diversity requirement in some context, including class action. So it's sort of the combination of those things that has made this problem maybe more acute than it has been in the past. I would love to see a push for that, or just a reconsideration altogether of the scope of diversity jurisdiction, and and whether it remains needed, in our current society. And there's kind of a question mark. There isn't a ton of historical evidence actually as to why we have diversity jurisdiction in the first place. I mean, I think the mainstream thought is, well, you don't want state courts discriminating against out-of-staters, so you need to have a neutral forum for those parties to go. But there's some evidence that it was actually kind of a specific problem related to debtor-creditor litigation. All that to say, I think it is worth revisiting both the monetary threshold and just more generally, whether we ought to reconsider at least the scope of diversity jurisdiction.
Thank you all.